Good afternoon, Mr. Bulso.
Good afternoon, Judge Clement. Good afternoon, members of the court. With the court's permission, I'll reserve 3 minutes for rebuttal.
3 minutes, yes, sir.
And for the record, I am Gino Bulso, representing all of the plaintiffs' appellants on the appeal. We have, I think, for the court this afternoon, an unusual case in that it arises out of conduct of a licensed attorney who engaged in a pattern and practice of forging quitclaim deeds, affidavits of heirships, other muniments of title, in order to obtain ownership of property that had been sold at tax sales in both Davidson County and in Hamilton County. There are a number of issues that have been raised on appeal by both sides, but with the court's permission, I want to focus principally on 3 issues. First, whether the trial court erred in its ruling that the plaintiffs failed to state a claim for unjust enrichment. The court ultimately resolved that issue on a 12.03 motion for judgment on the pleadings, but as the court is aware, it's the same standard that applies to a dismissal under Rule 12.026. The second issue would be whether the trial court erred in finding that the complaint failed to state a claim for intentional torts of trespass and theft. Also, the judge below resolved those issues on a 12.03 motion for judgment on the pleadings. Third and finally, the issue is whether or not the trial court misapprehended her role as a 13th juror and actually failed independently to weigh the evidence and satisfy herself that she agreed with the jury's verdict of a finding of no liability with regard to certain of the claims. The factual background is detailed, but actually can be summarized this way. This case arises out of these property tax sales, where we had a set of property that had the property taxes unpaid, not so much by the plaintiffs, but by their ancestors. In all but one case, the property involved in this case was not occupied nor were the taxes being paid by the plaintiffs in this case. They rather inherited the property through intestate succession from the deaths of their respective grandparents and parents. So to use Mr. Carl Chambers simply as an example, because it applies across the board, Mr. Carl Chambers, a plaintiff and appellant here, was a grandson of Maggie Chambers. And then when his grandmother died, one of his uncles actually occupied the property until his death, and then another relative occupied the property after his uncle's death. Mr. Chambers never actually lived there, but at some point, the occupant of the property failed to pay the property taxes to the Davidson County tax assessor, and the property was put up for a sale. And it was sold at a validly conducted auction sale. And when that happens, by statute, there arises this thing called a right of redemption in the property owner. And that was Mr. Chambers' right to go ahead and redeem the property for the amount of the taxes plus some costs within 1 year of the confirmation of the tax sale. And what happened in Mr. Chambers' case, which is similar to what happened in the other cases, is that Mr. Walker actually decided to obtain ownership of the property after the tax sale by acquiring the right of redemption. And he did it fraudulently and frankly, did it criminally. In the case of Mr. Chambers, he dummied up a deed that was purportedly notarized by a young lady named Jennifer Clark down in Dallas, Texas, whom we deposed. And we played all these depositions at trial. We had 7 different notaries who testified that the signatures that appeared on these quitclaim deeds and affidavits of heirships were all forged, that they were simply copies of documents that had been to obtain ownership of the property. So in Mr. Chambers' case, Mr. Walker got this deed put together, purportedly signed by someone named Alice Marie Smith, purporting to convey to him the right of redemption, which in fact belonged to Mr. Chambers. And he lifted Jennifer Clark's signature and notary seal from a different deed that had been recorded down in Texas. And then Mr. Walker recorded that dummied up and forged affidavit of heirship and quitclaim deed electronically. And that was significant and remains significant because in order to record a document, ordinarily a person has to go to the registrar's office and file the original, record the original, present the original. But attorneys can actually file documents, record documents electronically as long as they include this thing called a certificate of authenticity, verifying under oath that they have the original of the document that they are recording. And Mr. Walker, both with regard to the Jennifer Clark documents, with regard to the Jesse Berber documents, with regard to the Francis Nord documents, with regard to the Rhonda Norman documents and those of all the other notaries, he signed that certificate of authenticity, swearing under oath that he had the original of all these documents, which is complete and outright perjury, because there are not originals of any of these documents. And so in the case of Mr. Chambers, we look at this circumstance that happened. Mr. Walker acquired the right of redemption. He then went in and redeemed the property. The Davidson County Clerk and Master had no idea that these documents had been forged. So the property sale was set aside. The title went to Mr. Walker or his assignees. And then he ultimately sold that property for a profit of approximately $25,000. All the while, Carl Chambers, the lawful heir of his grandmother, knew nothing about any of these events. He had no idea that the property was no longer occupied. He had no idea that the taxes had not been paid. He had no idea that Mr. Walker had come in and done all of these things. And so when we were looking at this as lawyers, we say, well, gee, obviously Mr. Walker has done wrong and Mr. Chambers has suffered a wrong. What do we do here? What causes of action do we bring? And the first one that popped to mind was unjust enrichment, the first issue that I presented to the court. Because what occurred here is that Mr. Chambers had no interaction whatsoever with Mr. Walker ever. He simply was one of the heirs of his grandmother. And what happened here was that Mr. Walker unjustly acquired this right of redemption, which he then used to acquire title to the property, and then he sold it at a profit. That's all very unjust. And so one of the causes of action that we raised on behalf of Mr. Chambers and the other plaintiffs was unjust enrichment. The trial court said, no, this is not unjust enrichment because I read this court's ruling in B&L Corp. To require that the plaintiff have willingly conferred the benefit on the defendant. And it's true that there's language in B&L, a 2004 decision, that says that. But the problem is that there was no authority cited in that B&L decision for that proposition. And it was actually overturned the very next year implicitly with the Supreme Court's unjust enrichment decision in Freeman Industries, an opinion by then Justice Janice Holder. And what the Supreme Court said in Freeman Industries is that the benefit that the defendant receives from the plaintiff for purposes of unjust enrichment does not have to be direct. The Supreme Court said any benefit from a plaintiff to a defendant under circumstances such that it's unjust for the defendant to retain it without paying for it provides a basis for a cause of action. And that's the argument that we made below. We said, respectfully, Your Honor, B&L does not govern here. We've got the Supreme Court the next year, 2005, saying any benefit, whether it's a willingly conferred benefit or unwillingly conferred benefit. So that really is the issue before this court. The trial court said, with regard to unjust enrichment, that the benefit has to be willingly conferred for there to be a cause of action in Tennessee. Respectfully, that's not true. That's inconsistent with Freeman Industries, and this court should overturn her dismissal of the unjust enrichment claim and find, consistent with Freeman, that any benefit that flowed from Mr. Chambers, in this case to Mr. Walker, whether it was willingly or unwillingly conferred, provides a basis for an unjust enrichment claim. And with regard to the second issue, we've got something very similar. We have, once again, as lawyers, analyzing a claim. It was obvious to us that Mr. Walker had effectively stolen this right of redemption through a forged instrument. And so we brought an action for civil theft. The court below said, Unfortunately, you don't have a cause of action for a theft of an intangible real property right. Once again, we disagreed. We submitted to the court the State versus Gentry case, where in the criminal context, the defendant was convicted for having used a fictitious deed and later occupying a house he got convicted for actually stealing the property. And obviously, if there in the criminal context is a basis for using a fictitious instrument to obtain ownership of property, there would also be a civil cause of action. This is simply not something this court has passed on before. As I said at the outset, this is a very unusual set of circumstances where you've got a lawyer.
Excuse me for interrupting, counsel. So in the civil context, this is an issue of first impression
Yes, Your Honor. I believe
as
it
to
is.
whether such a cause of action exists in the state of Tennessee.
I would agree, Your Honor. And frankly, I think that's also true of the trespass claim, because Chancellor Martin dismissed the trespass claim, finding that there had to be a physical presence and trespass on the property. But in fact, that's not the case. When we actually look at the law, the way it's been applied, trespass is any interference with someone's right to property. It doesn't have to be a physical trespass, although it's not an issue, once again, that has come up. So I think both with regard to the theft and with regard to the trespass, we are dealing with essentially issues of first impression. But logically, when we look at the precedents that apply to either a physical trespass or a theft of tangible real property, the same principles apply. Those causes of action should not have been dismissed. In fact, they're the most natural ones that arise because effectively, Mr. Walker did interfere with Mr. Chambers' right of redemption. He, in fact, stole it through a forged instrument. And frankly, these would have been the easiest claims for us to proceed on at trial: unjust enrichment, theft, and trespass. But unfortunately, the trial court threw them all out of the pleading stage, and we never had a chance to present those. We only had a chance to present more difficult claims regarding fraud, which requires, as you know, misrepresentation and reliance, which is the difficulty here because the parties never actually met each other. And the same thing was true for the breach of fiduciary duty claims. That also requires a prior relationship, which never existed here. So unfortunately, based on the court's pretrial rulings, we never got to try what should have been the best causes of action for these plaintiffs.
Thank you, Mr. Bolso. We'll hear from you further on rebuttal. Mr. Hildebrand.
Good afternoon, Ned Hildebrand for the Appellees. Your Honors, this is a case about 4 individual plaintiffs who asserted specific civil claims against 3 defendants. Each claim involved a process regarding the exercise of redemption rights following tax sales of real estate. And as Mr. Bolso explained, redemption rights, that's the 1-year period following a tax sale where the delinquent taxpayer can go back to the court, pay the back due fees, taxes, and recover their property. There were a lot of claims in this case, but every one of the claims was based on allegations that the appellees misused the redemption process with respect to properties that the appellants allegedly owned in part at one point in time. Now, according to the appellants, as a result of the appellees' conduct, they suffered some injury, some loss that they otherwise would not have suffered. Certain claims were dismissed on dispositive motions, and the remaining claims went to trial. And at trial, the appellants failed to prove the essential elements of their case, elements that have been consistently argued since the case was filed, that these plaintiffs, regardless of whatever conduct the appellees were alleged to have done, these plaintiffs were not injured by it. They suffered no actual loss. The evidence demonstrated this overwhelmingly at trial based on the testimony of these appellants and the undisputed facts. And the jury, recognizing that, entered a unanimous verdict finding no liability against any appellee in favor of Ms. Ponce, Ms. Boer, or Mr. Chambers, no liability against Mr. Johnson or Greenwise Homes in favor of Ms. Irvin, and a limited judgment for misrepresentation by concealment against Mr. Walker in favor of Ms. Irvin. Now, the procedural history of what happened after this, I believe, is important. After the verdicts were entered, the trial court entered an order, which it called a Rule 58 judgment in conformity with the verdict. It awarded the limited judgment for Ms. Irvin, and it dismissed the remaining claims with prejudice, and it taxed the court costs to the appellees. It made no comment whatsoever about the sufficiency or lack thereof of the evidence presented to the jury. After that Rule 58 judgment was entered, a motion for new trial was filed, with the claim being that the trial court should exercise its function as the 13th juror and set aside the unanimous jury verdict. The appellees responded to that, and the trial court denied the motion for new trial. That Rule 58 judgment was then certified as final pursuant to Rule 5402, and this appeal followed. So the appellants have raised 4 issues. The appellees have cross-appealed on 2 issues. I'll address the issues briefly. First is the issue of the 13th juror. The appeal is that there was a unanimous jury verdict here. The appeal is that in denying the motion for new trial, Chancellor Martin did not exercise her function as the 13th juror. Well, there's no dispute that trial judges have a role as a 13th juror to pass upon the evidence and set a jury verdict aside if they're dissatisfied with it. When a trial court approves a verdict without comment, there's a presumption that the function was adequately performed. If reasons are given for the denial, this court reviews those only for determining whether the trial court passed upon the issues and was satisfied with the jury's verdict. And remand is only warranted when the comments of the trial judge indicate that they clearly did not follow the standard. There was extensive discussion in our brief about cases in which comments were found not to violate the function and comments were found to violate the function. We cited Shivers, Lockett, Washington, and Link, among others. In all of those cases, a trial court denied a motion for new trial, and in doing so, the trial court made the comment that sufficient evidence existed to support the jury's verdict. In each one of those cases, the appellant said that that violated the 13th juror standard by impermissibly deferring to the jury. And in each of those cases, the higher court found that that was not sufficient statement to show that the standard had not been followed. But conversely, in the case of Holden, which we cited, and the motion for new trial, the trial court expressly stated, had the jury come out the opposite way, he would have approved that verdict too. They found that that clearly violated the 13th juror rule. In the other cases, I believe Stanley and Miller, the trial court expressed that they had no authority whatsoever to even question the jury's findings, that those were exclusively within the province of the jury. That, of course, was not a proper function of the 13th juror rule. So when we look at the two polls we have here, on one side saying, I would have agreed with the opposite verdict, or I have no ability to question the jury's verdict, that's clearly not appropriate. But on the other side, saying that sufficient evidence existed to support the verdict is indicative of a proper exercise of the 13th juror function. So what did the trial court actually do in this case? Well, in this case, we know the trial court entered an order that it called a Rule 58 judgment, affirming the verdict and entering what appeared to be a final judgment in taxing costs with no comment whatsoever. Second, there was a hearing on the motion for new trial, which is in the appellate record, and the trial court talked specifically about the problems with the appellant's case, which have been raised by the appellees throughout this case, which is the inability to prove any damages proximately caused by any alleged conduct of the appellees. And then third, after considering all of those arguments, the trial court denied the motion for new trial and stated that the court does not find the plaintiffs have presented a sufficient basis for it to vacate the jury verdict. No error has been identified, and the court finds that a reasonable jury could have and did reach a result of no liability on the claims at issue. We contend that that is exactly like the cases in which the trial court said that sufficient evidence existed to support the jury's verdict. We know that that statement is indicative of an appropriate exercise. We contend that it is functionally identical to say that the trial court has passed upon the evidence and finds sufficient evidence to support the jury's verdict is functionally identical to the trial court passing on the evidence and saying that a reasonable jury could have and did find as it did. If sufficient evidence did not exist, then a reasonable jury could not have possibly ruled as it did. We contend that those are synonymous and that the trial judge did appropriately exercise her 13th jury function in denying the motion for new trial and preserving the unanimous jury verdict. The next issue I want to touch on is what Mr. Bolso raised regarding unjust enrichment that was dismissed on a 12.03 motion. And the trial court did, as Mr. Bolso said, make clear that according to the B&L case, unjust enrichment, it's not an all-encompassing theory that can be used to rectify any wrong that could ever conceivably exist. And it requires that a plaintiff willingly confer a benefit upon a defendant. In our brief, we not only cited that case, we cited a line of cases entered after that case that reaffirm that requirement. Now, when the appellants mentioned the Freeman case as overturning B&L, that's not the case at all. Mr. Bolso is correct that Freeman stated that the benefit conferred need not be direct. It could be indirect. But whether direct or indirect, that doesn't change the fact that it has to be willingly conferred. And in our brief, we actually cited the Travelers case, which is a federal case, but it specifically discussed Freeman as it applies to did direct and indirect moot the willing versus unwilling, and it said no. It said all that Freeman said is that the benefit could be indirect. It did not say that it could be, that it didn't change anything about the willing conferring requirement. But frankly, even if a willing conferring of a benefit were not required, based on the allegations, there's no basis for unjust enrichment in this case. I understand it's a confusing case regarding redemption rights, but the requirement is that the plaintiff confer a benefit upon the defendant. But this was not alleged at all. With respect to Ms. Ponce and Ms. Boer, there was no redemption that occurred at all. They didn't pay the property taxes, it was sold at a tax sale, no redemption occurred, and they lost title to their property. There was no benefit conferred on anyone by anyone regarding their property. With respect to Mr. Chambers, the allegations are that REO Holdings, who's a non-party to this case, acquired rights in certain property from someone other than Mr. Chambers. So whoever, REO did not acquire anything from Mr. Chambers in this case. He did not confer a benefit willingly or unwillingly on anyone in this case. Ms. Irvin's case is unique from the rest. She signed a written contract to convey her rights in the property and signed a deed to that effect as well, and that's undisputed. So the trial court correctly dismissed Ms. Irvin's unjust enrichment claims due to the presence of a valid, executed, and admitted contract. The last issue that the appellants have raised is this question of theft of property. And as it's openly admitted, this is not a valid claim under Tennessee law. They asked the trial court to create a claim to fit the fact circumstances here, and the trial court declined to do so. And we think that was a correct decision. Tennessee law already provides countless legal theories to plaintiffs when they have suffered a monetary loss proximately caused by the defendant's wrongful conduct. With that set of facts, there are ample legal theories available to a plaintiff. The problem that these plaintiffs have, and have always had in this case, is that notwithstanding all the allegations of wrongful conduct of the appellees, they were not injured here. Nothing that the appellees were alleged to have done proximately resulted in any monetary loss to these appellants. That's been the problem. And so while there's countless legal theories available to redress a monetary loss, there's not that many available when the plaintiffs weren't hurt, and that's logical, because in a civil court, that's the function of civil courts, is to provide a monetary remedy to compensate for losses as a result of wrongful conduct. I think that's exactly why the appellants have consistently stated and argued that if this was a criminal case, we would have X. If this was a criminal case, we would have had Y. But this is not a criminal case, because the function of the court is not to punish wrongful conduct, but to compensate for provable monetary losses. And in this case, there was absolutely no evidence of any monetary loss that any plaintiff suffered. In fact, as the record reflects, these plaintiffs didn't seem to have any idea about anything to do with this case. They didn't know anything about their properties. They didn't know anything about who the appellees were. They didn't know what happened. They didn't do anything to protect their rights. They didn't pay property taxes, allowed their property to get sold, and did nothing to redeem it. So we don't think that there's any basis to create new tort law here when it doesn't exist, because there are ample torts available to rectify remedies for monetary injuries. We shouldn't create one to rectify or provide compensation to a plaintiff who was not injured. The last issue before I'll get to our issues on appeal is they appealed the dismissal on summary judgment against Mr. Johnson for violating the notary statute. This is a statute where a notary has to verify the identity of a person and confirm that they signed a document. That is the scope of a notary's duty. They do not have to underwrite the veracity of a document. They merely confirm this is the person who signed this document. In this case, the only evidence presented, the only allegation in this case, and certainly it's undisputed, that the only signature that Mr. Johnson ever notarized was Mr. Walker's signature, and Mr. Walker's signature has never been contested. That was always a legitimate signature. The argument is that, okay, we know that he legitimately signed the signature, but he knew or should have known that the instrument itself was wrong for some reason, and he should be liable under the notary statute. Again, there are ample claims that would have redressed that wrong, perhaps fraud against Mr. Johnson, but the jury disposed of that claim in its unanimous verdict. Perhaps conspiracy to commit fraud, which the jury disposed of against Mr. Johnson in its unanimous verdict. But the notary statute is not one of them, and it's indicative of the plaintiffs, in this case, searching far and wide to find any claim that could conceivably apply to this case, of which there is none because no injury occurred. The last issues are the issues that the appellees have raised in its cross appeal. First relates to a lienless pendens. When Mr. Chambers joined this case in 2019, he recorded a lienless pendens against wholly unrelated real property owned by Greenwise Homes. He had never owned any interest in this property. He claimed no interest in this property. He recorded it functionally as a mechanism to secure an attachment of property in the event he could ultimately liquidate a claim against Mr. Walker and Mr. Johnson. We asked for that to be dissolved. In doing so, we cited authority that says that a lienless pendens, there has to be a claim directly related to the property itself. He has to be asserting rights to the property, possession of the property, and this was merely a prejudgment attachment with no bond. We even attached an order by the Chancery Court in another case in which Ms. Irvin was the plaintiff before she joined this case, in which that court dissolved her lis pendens for this exact reason. But the trial court did not dissolve the lis pendens, and we believe that was an error. And as a result, this property has been unable to be marketed or sold or financed for the entirety of this case. And still worse, it remains encumbered, even though now a final judgment by the trial court has been entered that dismisses every single claim that Mr. Chambers asserted at all. And in fact, in our reply brief, I believe we cited the Oliver case, it said that once the final judgment of the trial court is entered, the lienless pendens terminates. So even if the lienless pendens could have been valid at some conceivable point in the past, which we dispute, it's certainly not valid now that the trial court has entered a final judgment disposing of all of Mr. Chambers' claims. The last issue, I know I have just a little bit of time, is we challenged whether there any material evidence existed in the record to support Ms. Irvin's judgment for misrepresentation by concealment. Essentially, what's undisputed in this case is Ms. Irvin signed a contract to sell her redemption rights and her property to REO Holdings and then signed a deed to that effect. The claim she raises is that Mr. Walker, who was not a party to this contract, should have told her that by selling her rights in the property, she was forfeiting her right to go make a claim for excess proceeds with the Chancery Court. There was simply no evidence to support a finding of fraud by concealment here. The alleged non-disclosure was not a non-disclosure of fact, but a subjective legal opinion about certain disputed legal rights she may have. Mr. Walker certainly had no duty of any kind to disclose anything to her in an arm's-length transaction for the purchase of property. Ordinary diligence absolutely would have discovered this. In fact, she already knew about this. When the property sold at a tax sale, the court mailed her a notice that said, "We sold your property, we're holding excess proceeds, and you can make a claim." She then met with a man named Richard Chambers, who told her, "Your property sold at a tax sale, hire me and I'll help you get the proceeds." And despite knowing all of that, she willingly sold her rights in the property in exchange for cash. There is an argument about whether this issue was preserved on appeal, and we'll simply rest on the briefs with respect to the preservation of the argument. Thank you.
All right, thank you, Mr. Hildebrand. Mr. Bolso?
Sometimes cases present issues that have significance just to the case, and sometimes cases present issues that have significance beyond the case to broader Tennessee law. We've got issues in both categories here. With the one that I think is the most important to Tennessee law, it's this issue about unjust enrichment. Does Tennessee require that the benefit that the defendant obtains be willingly conferred? That is a very important question. That is the central question, I think, for this court on this issue of unjust enrichment. And we submit, when this court looks at the Freeman case and looks at the cases that Freeman cites, it's clear that the benefit does not necessarily need to be willingly or voluntarily conferred, because the Supreme Court cites cases from California and other jurisdictions favorably where the benefit was unwillingly conferred. In some cases where someone accepts a bribe for an employer, where the employer doesn't have a loss, but an employee was found to have been liable for unjust enrichment because that employee used his or her position to obtain a financial benefit. With regard to the issues in this case, that's important. This issue about the 13th juror is central to our jury trial jurisprudence in Tennessee. And respectfully, one cannot look at the court's final order and look at the transcript of the hearing on the motion for a new trial and conclude anything other than the court misapprehended its duty. The court's order denied our motion for a new trial because, quote, a reasonable jury could and did reach a result of no liability, close quote. That's the standard in federal court. That is not the standard in Tennessee. In Tennessee, in response to a Rule 59 motion, the trial judge is obligated independently to review the evidence and reach a decision that the court agrees with and is satisfied with the jury's result. And if the court is not, the court is duty bound to set aside the jury's verdict. Here, when we look...
In other words, the judge needs to say, I'm satisfied. Is that what you're saying?
In part, Judge Clement, if the judge says nothing, if the judge simply denies it, then the court presumes that the judge exercised the role properly. But when the court speaks about the reasons, the court needs to indicate that the court understands what the significance of the role is as a 13th juror. And when the court looks at the transcript where we argued this, October 15 of 2021, I believe it's volume 20, page 5725 of the record, Chancellor Martin and I went back and forth about this, and she said, well, Mr. Bulso, couldn't a reasonable jury have accepted this testimony? And I said, respectfully, Your Honor, that's not the question. The question is whether you, independently reviewing the credibility of the witnesses, accept that testimony is true. And if you don't, you got to set it aside. But ultimately, the court did not accept what we submitted as the court's proper role as 13th juror, and she decided that because a reasonable jury, quote, could and did reach a result of no liability, that the motion should be denied. That was error.
Thank you, Mr. Bulso and Mr. Hildebrand. You've given us a lot to think about. We'll take your matter under advisement.